Good morning, or good afternoon. It might be afternoon for some of you right now. Listen, happy hump day, happy Wednesday, happy 2 days to Friday, all that jazz. So, couple of things. Today will be a little short because I think the hearing, so we do have to catch up on the hearing. Hearing happened yesterday for Rashad and Davion Murphy, Isaiah Chance, and Baby Rambo, what name? Sean Gathright. So, the last hearing that we watched, Judge Cisco said, how bad do you want it? As far as if y'all really need this evidence, which was an item that was in Sean Gathright's phone. Also, there were some messages between Alicia Andrews and Isaiah Chance that the judge did say out of all the things that the defense brought up, those two things at least would be inadmissible against the others if they were in trial by themselves. So therefore, putting it in a trial with everybody all together would be a no-no, and she would have to sever some folks, and she wasn't going to guarantee that she was going to do multiple juries. So we now have, that was 2 weeks ago, and of course, now, yesterday, there was the next hearing, which I will, spoiler alert, there's one more hearing, but that next hearing on tomorrow is actually only for Davion Murphy. Everybody else has waived appearance, so he'll be the only one there for one more motion for him. But before we get started, I do have a question for you guys, because I have been on the fence about it. I have been standing 10 toes down as a possible hard no, but I keep getting requests for it. How do you guys feel about the Courtney Clenney case? Or people refer to her as the OnlyFans model case. She was the young OnlyFans model who was dating the melanated guy, Christian Obumseli. They had a tumultuous, toxic relationship. And I think the last domestic dispute they had on record was exactly 4 years ago today. And within 2 days of that last dispute, he had something up in his chest. He was stabbed in his chest. Now, at first, Courtney Clenney, thank you. At first, Courtney Clenney claimed that it was an accident, that she actually threw the item and it, like a playing darts, landed in his chest. Now she's claiming it was self-defense from a domestic dispute, but we know that there has been quite a bit of information that came out about their relationship, right? And we know that has also come with some surveillance. Like the infamous elevator footage that's been around a whole lot. She's been locked up for about 3 years, right? So there was infamous elevator footage where she's pushing and beating on him. She was known, there's lots of video footage and cell phone footage of her going upside his head. They say it was toxic. I think it was even one time, didn't she poke him in the leg with something, and he was like, just please, just let me in. I don't want to fight anymore. It's okay. I'll be fine. I think I really need a doctor. And he was just getting his ass whooped, for lack of better words. I don't mean that in a harsh way, but I think it comes out harsh accidentally, but on purpose, but purposely accidentally. I think it comes out that way because during these problems, Christian Obumseli had a very, very, very candid opinion that he voiced a whole lot across Twitter and Instagram when he was younger. His Christian Obumseli, this is an interracial relationship, and Christian Obumseli had a lot to say about women that look like his mama. Okay, he And at first I said, you know what? I respect the dad. And I don't think that man would want me saying his name. I don't think he would have liked me very much. I don't think he would have liked to see me breathing. And he just had a very, very, very strong opinion about women that look just like his mama. And then the one that don't look like his mama is the one that was whooping off in his tail and took him up out of here, and is now claiming not only was it an accident, but now she went from accident to self-defense when she has obviously been going upside his head for a while. Now, I originally stood on the business that I know his mother came out and she had a lot to say to vloggers and folks on social media, asking them. She apologized, you know, post habeas. She apologized on behalf of her son after he was no longer here, saying that, you know, that wasn't really her son, not the way that he acted, any way that he would have, anything that he would have said that would have been offensive. She does not want that to come in between the fact that he deserves justice. Now, I do give her that. The same way Julio Foolio don't deserve to be taken up out of here. Don't nobody deserve to be taken up out of here just because you don't like things that they do or say. But ain't it just like a mama? To come through trying to make good, because she probably knows that the only way to combat this type of situation with whom or what he was taken out by is she's going to need somebody on her side. She's going to need some people to make noise. She's going to need some people to say, hey, because in those situations, the overarching stereotype is that he would have been the aggressor, which in most cases, lots of videos show that he was not. So it looks like in that case, it's had a lot of delays, a lot of damn delays. You know, even her mama and daddy was Courtney Clenney's parents were even picked up at one time because the cops even, true to fashion, the cops even left Christian Ogunseyi's things in the apartment where him and Courtney Clenney lived. And then afterward, they found on a jail call that Courtney Clenney was instructing her parents on how to get into his laptop. So there were things where they found out that they were trying to get into his laptop, ergo with evidence. So I believe at one point, Courtney Clenney's parents were even arrested for tampering with evidence because they had taken his laptop and other things from the apartment and did not give those over to the authorities. They attempted to break up in them with what she thought was the password, and they didn't get in. Really, we are talking about what will be Florida versus Courtney Clenney in the unaliving of Christian Ogunseyi, and I am still torn about whether or not I want to cover that. Now, it could also end up in a double duty type situation because that case, we thought it was going to start last year a couple of times, and it's actually supposed to start April 27th. Now, we know that as of April 8th, they're going to start picking a jury for Julio Foolio's trial. They expect that to start on or around April 13th, maybe the week after. So it could happen. Now, from what I'm hearing, they are trying to push through this Julio Foolio with the quickness. Okay. I would have been in this courtroom screaming, but I'm trying to determine, Jay, if I really want to put myself in that situation. Because again, some people might have said, oh, well, you did it for Julio Foolio and he was a troll. But don't nobody deserve to lose their life. But I really think she thinks she winning. I think she thinks she gets to claim Big Bad Wolf, even though she was laying hands and feet on that man. We'll see. We'll think about it. We'll think on it and think about it. Okay. That's what we're going to do. But we're going to get to, this is the hearing that happened yesterday for the other 4 co-defendants for the unaliving of Charles Jones or Julio Foolio. We know that Alicia Andrews is currently in limbo. We know that she did get this particular judge in this case, Judge Cisco, kicked off of her case. And these 4 men are facing the needler. Okay. So they are trying to go through. Currently it's set for April 27th as far as the last thing I've seen, but I'll look it up again. I get your apprehension because I know it's probably gonna come out of me. I know I'm probably gonna say something. But at the same time, I'm sure people feel a way about Julio Foolio and probably other people. But at the end of the day, they're still the victim. So Boom Selly. Your last name, Boom Selly. Who did you think you were? Your mama should have slapped you in your mouth the second you tweet anything about it that looked like your mama. She probably hated them dogs too. But let's get to it. This is the hearing that took place yesterday to finish up the motions and to look into whether or not they would sever. It got interesting, y'all. I was watching it yesterday. Okay, but here we go. Oh, thank you, Hannah. Let's see.
Okay, very good. The defendants are present. Defense counsel is present. The state is present. And I need to get my glasses because I can't see until I have my glasses. Okay, so I'll be right back.
We about to have a couple.
No. They're in the office there, either on the desk or in my purse on the interior pocket. Thanks. I set him down, then I'm like, yeah, I can't see. Okay. So I have reviewed the following motions. Isaiah Chance has a motion in limine, and the state filed a motion to compel disclosure of raw data generated during administration of tests for a number of the defendants. And then Rashad Murphy filed a defendant 6 motion in limine as to Robert Howard. Are there any other motions that we need to hear today?
Now y'all remember Robert, right?
Judge, I believe Mr. Harmon filed yesterday a motion for order in limine having to do with the verdict of Alicia Andrews. Did you receive that?
I don't believe that I did.
Real quick, Robert Howard might hit way different in this trial.
Did you figure out if he brought that jacket home or not? Did you stop by there or did you send her a message?
I sent her a message. She didn't respond about the jacket.
Okay.
She just took the papers out of his bag that I was asking about, but she didn't respond about his jacket.
Okay.
He's a Robert snitch. Robert gonna hit a little different in this one because Robert, they said, hey, big aunt. Babe, they said, hey. He said, hey, he up there cooking. But it's a little different to try to claim that Alicia Andrews knew everything that was going on when Robert Howard kind of knew of her or knew who she was, but he never spoke to her. Robert Howard may hit a little different because Isaiah Chance actually contacted Robert Howard and said, y'all boys better be on point down there. That's going to hit a little different because Isaiah Chance is sitting in the room this time. I'd have emotion about Isaiah too. Just like, was it liar, liar? On the grounds, he's hurting my case.
It was filed yesterday.
I thought we discussed that already, but
We did briefly, Judge, and I think that's why Mr. Harmon filed the motion.
okay. Yeah, and I indicated that it was certainly not relevant during guilt phase.
And so this has to do with penalty phase.
Okay, well, I don't know. So, all right, I haven't reviewed it yet, so I'll take a chance and take a look at it. Take a second and look at it after we do these. Okay, y'all care which ones we start with?
Judge, I think Ms. Isburn was hopeful that we could do Mr. Howard's motion in limine last.
Okay, sure. All right, so why don't we start with the state's motion to compel disclosure of raw data generated during administration of tests. And I have a motion filed as to Rashad Murphy, Davion Murphy, and Isaiah Chance.
Very quickly, just for the record, Christopher Delauder is going to be sitting in. He is a certified second phase attorney. He wants to get some experience on first phase. So he will be sitting in with myself.
For the remainder of the trial or just today?
That's correct. As much as he can. Really
Sure. That's fine.
The court to be aware of that.
Yes, thank you. Good morning. Okay, so those are the three defendants.
The location.
Did Mr. Gathright, do you have one as to Mr. Gathright or not?
I don't think Robert gave the location. I think Robert was the one who was hosting with, not only hosting with Julio Foolio, but Robert was the one who actually did 5 years for that popping at the high school that they kept referring back to. And he's the one that actually popped the Murphy's little brother. What is the little brother, the little cousin? So Rashad and Davion Murphy were supposedly had this chip on their shoulder about their little brother or little cousin being taken out at that Rains High School shooting. Howard went and did 5 years for manslaughter for that popping. And they claim that Rashad and Davion Murphy were after Howard or anybody with him because he was the one that went to jail for it. But remember, he never made a statement to anybody. He just went and took his 5 years on the chin. So therefore, who they felt also did it, which was Bibby. They felt like Bibby got away, but then Bibby ends up getting unalived. Now we know is attributed to the recent guilty plea taken by Queso a couple weeks ago that he was the one that did Bibby. So that explains that back and forth. The only difference is it didn't really make a whole lot. It felt like a bunch of he say, she say swirling around over top of and around Alicia, but none of it really touched Alicia. But in this one, I think he was considered a juvenile, and they never proved that he was the one that actually did the popping, but he never said that he did or didn't do the popping. He just took his time and went and sat down. So, Ms. Kathy, they were never able to prove that. They know for a fact that they were pretty much under the impression that Howard didn't do the popping, but he's the only one that went to jail for it. So they couldn't prove that he did the popping, but they put him in there because he wouldn't say who did it. So, hey. So it's going to be a little different with Howard on the stand because remember he said, I think it was one of the Murphys contacted him and said, I need to holler at you. Remember Robert Howard also said, I think it was Davion Murphy walked up on him while he was in jail and was like, I'm going to see you. We need to talk about my brother. So it was different with Alicia in the room because they weren't really trying to talk to Alicia. But to know that the person that, I did hear that, Hannah, the person that actually went to jail for taking out the person that they're mad about is Howard. And when he testifies, He actually talked to Isaiah Chance on the phone when Isaiah Chance said, y'all better be on point down there. He actually got ran up on by Davion Murphy, said, we're going to be on your ass about our people. And now their people are convicted of taking out Bibby, who they really thought was allegedly the trigger man. Robert Howard going to be real fucking interested in this trial.
No, Judge, these were, it's my understanding from Mr. Harmon, these were the only 3 defendants that had mental health experts in this area.
Okay. So, Mr. Gonzalez, as to Rashad Murphy, do you object?
Judge, I think that would be a.
Oh, I'm sorry, Mr. Hernandez, do you object?
What motion is this?
It's the state's motion to compel disclosure of raw data generated during administration.
I got
of
chips for my dip, y'all, so I'm going to mute
Obviously, that is
for a
done
second.
directly from one doctor to the other. We don't get involved in it, but I can contact my doctor and it gets sent directly to the state's doctor.
Okay, and obviously, and I don't know, only you know, in the raw data, your expert may know, if there's anything in there where the defendant spoke about the facts of the case or defense strategy, then obviously that data does not have to be disclosed to the state.
I would have to check with the doctor, but based on the deposition that was taken once a week, I think that that's not going to be an issue because in response to one of the questions, my doctor indicated that the defendant had not discussed whether any issues regarding guilt or anything. So I don't think that's an issue, but I would have to double check with the doctor.
Okay, well, just make sure that they know before the data is conveyed to the state that if there is anything in there that that can be redacted or withheld, but you just need to, essentially, what I would need the doctor or you to do is to make some type of privilege log, just so it's reflected that this is what we held back and this is why. And then if there is a finding of guilt as to first-degree murder, and if we're going into a penalty phase, then potentially that material would have to be disclosed, but we can discuss that if we get there.
If once the state can provide me an email for the doctor, I will reach out to my doctor to have it sent with the court's instructions.
Okay?
That's fine, Judge.
Okay, very good. All right, so as to Mr. Sonardi, as to Davion Murphy, do you object to the motion?
Yeah.
Or, go ahead.
Yes, correct. To the state's motion you're referencing?
Yes.
Yes,
Okay, just, you don't think any raw data should be at this point disclosed?
correct,
Based upon what?
correct.
No, based, what is your argument? What's it based upon?
I'll just adopt the other co-defendant's arguments as to that.
Okay. Okay, so I'm going to grant the motion with the same exceptions. Mr. Sonardi, you just need to confirm with your expert that they are to supply the raw data you get the information regarding the state's expert. However, if during the interview of Mr. Davion Murphy, if he made any statements regarding the facts of this case or any defense strategy, then those statements or that data does not have to be transmitted, but you do have to create a privilege log if you're holding it back. Okay? All right, and finally, as to Mr. Isaiah Chance, Mr. Petratus.
We would object. I spoke with our doctor, and her concern was that the state's doctor is a psychiatrist, not a psychologist. We're going to be trained in the test that she administered, simply to Mr. Chance, based on that.
Okay, well, that sounds like a jury issue, potentially, cross-examination or direct examination issue. So I'm going to grant the motion. Again, Mr. Petratus, the same thing. If there is anything contained in the raw data regarding defendant statements as to the facts of this case or as to any defense strategy, that does not need to be conveyed to the state's expert, but you would need to create a privilege log. Okay? All right, very good. All right, so Mr. Chance's motion in limine and state, do you object to this motion?
Yes, Your Honor, the state this morning filed a response with its motion limited. It was filed yesterday, provided courtesy copies via email to the court and provided physical copies to the defense attorneys as well for courtesy email this morning. We included the argument from Mr. Petridis as well as the argument on behalf of Davion Murphy for the YouTube videos that were listed. Mr. Petridis.
Well, this is all I've got. This is all I've got. Mr. Chance filed a motion in limine and wishes to have excluded any allegation, mention, inference, or indication, whether through witness testimony, picture, video, or attorney statements to the jury of music video or stills from the video, quote, blood on my Pradas, close quote, by Isaiah Chance. Said video has no direct connection to the murder of Charles Jones and has imagery, firearms, dead body, etc., that would be unduly prejudicial without any probative values. That's what I'm referring to.
Yes, Your Honor.
Okay, so you're objecting to that.
Yes, Your Honor.
And what's the basis of the objection?
The evidence, there is items or are items of evidentiary value contained within that YouTube video presented at the state's evidence view. The state did decide to utilize screenshots in lieu of the video itself. Those screenshots depict the defendant only, not the dead bodies in his videos, and all of the violence from the videos. We actually limited the exhibit itself to several screenshots, many of which prove up elements that are required for the gang enhancement.
Okay. And what's your response to that, Mr. Petridis?
Just not withdrawing my previous objection to the gang.
Right.
But if it's just photos of him with the, I assume the 23 chain, stuff like that.
Do you have the still shots here?
Yes, I presented the still shots we used at trial at the evidence view to defense.
Okay.
I have them electronically as well on my computer, Your Honor. I can pull them up if necessary.
I have the 3 photos, I believe. 2 of them just Mr. Chance with a 23 chain. There's no other imagery that we would object to. The other issue is, though, the name of the video is one of the pictures, and I would object to the name of the video.
Okay. What's your response to that?
The state, in admitting the evidence, is proving the authentication of the video and the source from which the video derives. So, identification of the defendant, number one, given that the subscriber information records linked to this defendant.
Exactly, Keisha. I don't think they can prove much of a gang with Isaiah Chance except for what videos or social media posts. Didn't they say in the last trial that he claimed like 3 or 4 gangs in less than 2 years? You can't skip, hop, jump. And then the gangs that he's claiming are all, the names are attributed to neighborhoods. He ain't lived in not in one of them neighborhoods. Not never. So I think this is the only way they can attribute him to a gang, because he was out here just claiming a gang of anything, anybody. And honestly, that's the only way that they can keep Sean Gathright connected to all of them, because he wasn't claiming nothing.
Title that's used or the name that is used by the defendant is not his legal name. So it's more than just authenticating the video, but also identifying the defendant for purposes of this exhibit.
Okay, for record purposes, we probably need to identify exactly what it is we're talking about. Can you either display it so I can see it and Mr. Petridis can see it, or you can?
Yes, Your Honor.
Also, while you're doing that, we had a superseding indictment, correct?
Judge, that is correct. The only thing that has changed is count 2, which is the conspiracy count. We expanded the time frame of the conspiracy back to June 6th of 2024. That's the only change to the indictment.
Okay, Mr. Gonzalez, on behalf of Rashad Murphy, how does your client plead?
We would plead not guilty, Your Honor.
Okay, Mr. Sonardi, on behalf
You had to
of
open up the time frame because he was whooping your ass with the time frames 2
All right,
weeks
Mr.
ago.
Wise, on behalf of Mr. Gathright, how does your client plead? All right, and finally, Mr. Petridis, on behalf of Mr. Chance, how does your client plead? Okay, very good, thank you.
So they didn't pull the superseding indictment in 2 weeks. So we know that a superseding indictment means they either add, change, or otherwise judge up some charges in there. Now we do know, we've seen it with YSL, with the RICO, that they would add things saying it was a continuing or furthering of the gang, even if it was a phone call made today in the jail about what they were claiming from 2014, right? So apparently, remember when Mr. Man was getting up there talking the ears off a donkey, he kept saying that falls outside of the time frame of the actual conspiracy that you've already given, because they're saying it's from this date to this date that they planned and executed their wrath on Charles Jones. Now all of a sudden they've taken that back a few days. Okay, let's see how this goes. They didn't add anything. The conspiracy charge, they actually changed the date.
And while we're waiting on Ms.
Timeline
Smith,
for the
let's just talk
conspiracy.
a little bit about jury
Let the
selection,
games
okay?
begin. Come on, Lawyer Brian.
So, well, I spoke with Jury Services, and they're summoning enough people, they hope, to at least get 150 in here, okay, 150 people. Actually, let me back up. We're not doing jury selection in this courtroom, okay? So we're doing it in courtroom 1. So we have just because I'm going to need to be able to utilize the lobby outside to seat people, and there's no lobby outside of this courtroom that would be large enough to accommodate 150 people. So we're going to do all of the jury selection in courtroom 1. We're going to try the case in here. All right. So I know we can get 150 in the audience on the benches. My bailiffs also determined that we could get an additional 25 in the jury box with some chairs in front. So conceivably, if 175 people show up, we can get 175 in courtroom 1. My inclination is if we have the space and we have the people, we should just bring them in. So that's my initial thought on that, is that it actually would be 175 people, assuming we get 175, Wednesday, Thursday, Friday. So then my question to you all is, as far as numbering them, my inclination is to do 1 through 150, like normal, like what I normally do in the audience and the benches. And then do 151 through 175 would be on the side where the jury box is. And remind me, Ron, Reggie, how many chairs do we have to put in the front?
In the jury box?
Yeah, outside the jury box.
7, 6, 6, 6.
Okay. So what I will do is I will have my JA come up with just a general seating chart, so you know the numbers of where the people are going to be. All right. And then starting the next day, then we would start with 176, put 150 out there. And then if we get the extra 25, again, put them on the side, and the same thing with Friday. All right. So I will do seating charts for you all with that anticipation, and you can at least use that. Okay.
What the hell?
Involved in the length of the trial, I suspect a lot of individual work on it. How do you plan?
So this is what we do with regards to this first round. And I think we discussed this before, but you may not have been here with Mr. Hernandez. So how this is going to work is phase 1 is going to be questioning with the jurors about hardship and whether or not they can serve, and then pretrial publicity. So what I'll do is when we get the list of 175 names, all you all are to do is simply write down the name and the number. That's it. Don't start looking at slips. We're just get down the name and the number. I will give my introductory speech that I do in all death penalty cases. Plus, I normally don't instruct them on the death penalty at this phase. However, in this case, I am going to give a preliminary instruction because, unlike my normal practice, I am going to break down the people that can serve into smaller groups for death penalty voir dire. And the initial instruction on those jurors normally takes a while because I know I have a long speech I have to give. The state normally gives a relatively long speech, and then the defendants can give whatever speech they would like to. And I don't want to have to repeat that every morning during voir dire of the penalty phase, which would be phase 2, because it just sucks up time. So I'm going to give my preliminary instruction on the death penalty. I will then allow the state to give a preliminary instruction. You all can give a preliminary statement if you wish. And then what I will do is I will then ask the jurors 2 separate questions. I'm going to ask them first to raise their hand if they're going to claim a hardship for while they cannot serve. And then I'm going to read a statement, and I need to get an agreed to factual basis from you all to read to the jury and ask them if they think they know anything about this case. I will probably, so for those individuals that raise their hand as to knowledge about the case, pre-trial publicity, I will do individual voir dire, and we'll do that first. We'll bring them in one at a time. For those that are claiming a hardship without pretrial publicity, I will do those in groups. So I'll bring them in, probably have enough to seat in the first row of the audience, and then I will ask them the initial question as far as what their purported hardship is. And then I will allow each of you, if you wish, to do any follow-up questions. And then once all of those individuals have been questioned, then we will determine who can be excused. And at the outset, just so you know, I will excuse people for cause at mostly at lunchtime and at the end of the day, but only if everyone agrees. So if anyone objects, either the state or any of the defendants, to any of the prospective jurors being excused for cause at that juncture, I'm going to leave the person in the pool. So because you may want to rehabilitate them, I don't know. Okay. So the individuals who do not raise their hand at all, who don't know anything about the case and who are not claiming a hardship, they will be excused until Monday. And then they will come back to begin the first smaller group for death penalty questioning, which is phase 2. So my goal is to hopefully have smaller panels of 30 to 40 people just for death penalty voir dire the following week, which would be Monday through Friday. And then once that is finished, then the following week, Monday and Tuesday, will be general voir dire for those that remain. All right. So I am well aware of the number of peremptories, 40 total for defense, 40 for the state. So I'm hopeful that we will have, at least 150 come back for the final phase. We'll see. So this is just going to be a situation where as we go along, we will see how things are going. All right. So then if I get, let's say, more than 30 people who can come back the week 2, I'll push some to Tuesday. And then same thing, Thursday people will come back either Tuesday, Wednesday. Friday people that come back will come back Thursday or Friday. I won't know until I know what the numbers are exactly what day they're going to come back. But just so you all know, it will be smaller panels week 2, 30 to 40 just on death penalty. Okay. So Mr. Hernandez, is that a long-winded way of answering your question? Okay.
Judge, one question I have.
Sure.
The statement that the court's going to allow defense and state to make after your initial inquiries, what is the court anticipating with regard to that statement?
I'm assuming it's just pretty generic, just enough to trigger their memories. We had a statement in the Alicia Andrews case that you all may or may not agree to, but it's kind of just basic parameters, things like this was a shooting that occurred up near USF on the date in question, and that it involved an allegation of potential gang involvement, and the victim was Charles Jones, known by his rapper name Julio Foolio, something like that.
And that's the statement that's going to be given by the court.
Correct.
What about the statement that you're referring to that you would allow both the state and the defendant?
That is the statement. No. The statement
You're
that I,
talking about something that we are allowed to get up and do at that.
yeah, no. No. There's two separate, I guess, statements. So the first one is the one I would make in anticipation of my question about pretrial publicity. Okay. The next would be with regards to the death penalty information. And again, just from experience, Mr. Harmon has a script that he uses, and I don't believe in any of the cases I've done, defense actually said anything in addition, really. So you don't have to. I'm just letting you know that if you would like to stand up and just give because I'm allowing the state the chance to do it, to give a general instruction or information about death penalty qualification.
Fine, Judge. I need some clarity.
Yeah, it's just, I don't think any defense attorney has ever done it, and you don't have to. I'm just giving you the opportunity if you so wish.
Understood.
Okay, but normally between myself and Mr. Harmon, we cover pretty much everything. So, okay. And I'm also considering, and you guys tell me if you think it's a good idea or a bad idea. Once we get our jury picked, so this would not include next week, I'm considering giving the jury Fridays off. Mr. Sonardi gave me the thumbs up. You guys. I'm hoping that will be some sweetener to encourage people to want to volunteer to serve, since they know they at least will get Fridays off to handle their personal affairs or do what they need to do. But you all tell me.
Certainly always a good situation with regard to getting people to want to serve, and certainly allowing lawyers to do what they do. I don't know if the state has any indication. We haven't gotten a final witness list yet, which of course no one's obligated to do.
Right.
But to the extent, would the state have any indication as to what they think their case in chief, short of a catastrophe, might take? I'm just more looking about, quite frankly, Judge, my calendar beyond
Sure.
the 15th. And there are some challenges there. I need to know whether the state has any idea as to what they might.
So let me ask you this. So let's just talk about this a little bit. So hopefully, if everything goes smoothly, jury selection will be concluded by Tuesday, April 21st. Okay, that's my goal. I will be working very hard towards that goal. That means we do opening statements on the 22nd and begin with the presentation of the evidence, the 22nd and the 23rd. I can tell you right now, we will not have court on the 24th of April. So then the guilt phase portion would begin again April 27th. And we'd go through that week. And then depending upon things and depending upon if there's a finding of guilt as to first-degree murder, penalty phase would begin May 4th or thereabouts and last most of that week.
Does that report potentially with what the state would anticipate from a case in chief standpoint? And again, I'm asking a question that they may not have the answer to, Judge. I'm just inquiring.
I think that in general terms it does. I know that this trial will be somewhat longer because there's more attorneys, but
Sure.
I think that that's a good general guideline.
So I'm trying to remember how many days did it take us in the Andrews case? 7? Well, remember we picked a jury though.
Correct.
Starting, I can't remember, did we start Wednesday or Monday? I think it was Monday. Did we start Monday?
Judge, I don't know.
Yeah, I don't
I'll have to go back and look.
either. Let me look. I don't know. What month even was that? Who could
I know
even?
It came in on October, on Halloween.
Okay, let me look.
5 years ago now?
Yeah, it feels like it. Yes, it was. Yes, it was. Okay, well, I have that with me. So anyway,
That gives me a much better indication, Judge, without nailing anybody down, that actually answers my inquiry. truthfully.
yeah, it took us a couple days to pick the jury in that case. It took, 2 to 3 days to get the jury picked. So it took us, I'm going to say, about 7 work days to get it tried. So maybe 8 or 9, just because we have more lawyers, but I would say 8 or 9 for guilt phase portion of the trial.
There may be a few more witnesses in this case.
Okay.
And baby,
And probably a little more extensive testimony from those witnesses.
baby, and that's why I would have passed the hell out. Because y'all are talking about ending my life. And y'all trying to cram it in these many days? Sir, clear your fucking calendar and save my life. Like, what? Yeah, I wouldn't have been able, you'd have to medicate me. Because ain't no way y'all going to sit up here and tell me that that's what y'all planning on doing. I wouldn't be able to, I mean, I can't, of course, we never know if somebody is innocent or not. Of course, we're looking at guilty or not guilty based on the law or the case that's presented. So please don't get it. I know y'all won't do it, but for anybody that may see this later, I'm definitely not saying anybody is innocent. What I'm saying is, as a human being, if I'm sitting there and y'all are literally condensing whether I live or die down to 2 weeks, I know there are some that will say they did the same thing to Julio Foolio, but right now they are cloaked in innocence. So we're going to go with that. Baby, I'm just saying, no matter what I did or didn't do, if I was sitting there and hearing people talking about moving on with their lives and going on with their schedules while they're condemning me to die, I would have lost it. I don't know that I would have been strong enough to sit there and just hear that and not have a reaction. Because what the fuck you mean May 15th? She just said we ain't gonna get started around about 22nd, 23rd. She trying to give people Fridays off and get me done within a certain amount of time. Baby, you better put them Fridays on there with a couple Saturdays and a little Sunday morning early service or something.
I think there were some limitations.
Sure.
In the Andrews case that probably don't exist here.
Sure. Okay. So, yes.
I guess along those lines, I think it's safe to say that
Ooh, child. That's got to be a tough one to hear.
I shouldn't have any witnesses ready in April. It should be May.
Yeah, it'd be May. I would say May 4th at the earliest. May 4th at the earliest. And I'm going to ask Mr. Hernandez,
You
what's your
said April
absolute need to
23rd.
be done by date? Mr. Gonzalez, what's your absolute?
We
and
done,
Mr.
we
Hernandez, what's your
done.
absolute need to
Don't
be
done by date me. Oh.
Judge, preferably the 18th or 19th of May. I don't know whether any of those days fall on the weekend, but.
Yeah, we'll be done by then. Okay. Mr. Sonardi, what about you? Any?
Fine.
Okay. Mr. Wise?
Your Honor, my only, sounds like, I'm on the same boat as Mr. Gonzalez. I had everything blocked off for May 15th, so starting May 18th, I have.
Oh, all y'all had decided on May 15th. It
Yeah.
must be another big.
We'll be done by then.
Yeah.
We'll be done by May 15th. Okay, we will. And Ms. Petratus? Okay.
Oh, you will?
We will. So, okay. Very good. So now that we've discussed the calendar, so at this point, I won't commit to the jury taking Fridays off. I will tell them Friday, April 24th for sure. And that if we're making good progress and it looks like I can give them a Friday off, then I will. But at this point, I'm going to be conservative because it's more important that we, the trial gets completed in a timely fashion. So, okay. Okay, Ms. Ismer. Yep.
Yeah, the signature, that's the result of these guys. That's what it looks like. And Connie made that
Yeah.
sheet in the back. Want me to just make a copy and give it?
That'd be great. Excellent. Okay, so this would be, the state is displaying, this is a still shot, blood on my Pradas. And that is Goudaze, which I believe is
Gouda,
a name
not
that
no
Mr.
cheese, honey.
goes by, correct?
Yes, sir.
Okay, and
She didn't call the
when
board
was
cheese.
this distributed or?
I'd have to look back at the original motion for the date.
Okay, or posted? September 2023?
I
Okay,
think the 8th of 2023.
okay. So this is the one you object to,
This specific picture.
this specific
And
picture.
I'll say, we're not gonna be objecting to Detective Meter or someone who knows him saying that that is Mr. Chance. And we're not gonna be objecting, that is the name, the top Jose that he uses. But I don't, and we're not gonna be objecting to this, based on your ruling. The other two pictures, which is him wearing a 23 chain,
Okay.
shown in this picture. So I'm not gonna object to this and then try to jam up the state later, but it's this specific picture. I don't think it's necessary to show blood on my product.
Well, yeah, so what if they just redacted blood on my Pradas?
Well, I would say
No.
that,
Looked like he did everything they're accusing him of.
could be interpreted negatively. Whereas they're just trying to show him wearing the 23 chain in the music video. I don't want to say stipulate, but I'm not going to object to suggesting this was a video he made on September 8th, 2023. That is Mr. Chance, and he's wearing, it can be very obvious in the other two pictures, a chain, number 23 on it.
Yeah, well, it looks like, just for the record, it looks like he's maybe mimicking shooting a gun or shotgun or something. That's what he appears to be doing. So why do you need the title "Blood on My Pradas"?
All of the other exhibits from YouTube include the title and the account name for the individual who posted them. So to redact only this screenshot or only this defendant's music video, which indicates obviously still images for at least this exhibit of the defendant wearing his gang chains or talking about offenses or crimes that are linked back to the gang that he's affiliated with, I think it causes a discrepancy in what evidence is being presented. The defendant would, in this instance, be the only person whose music video title isn't also displayed alongside of all of the other videos which are establishing his gang enhancement.
All right, let me see the other still shots, just to make sure, for the record.
This is still shot 1. And still shot number 2. Both have been redacted to remove the guns or body parts that were depicted.
Okay. And this is going towards the gang enhancement, correct?
That's correct, Your Honor.
Okay.
We'll seek testimony as to the lyrics because in playing the video, obviously, we knew the defense would have an objection to all of the content, which is why we redacted to these specific images.
Okay, very good. All right. So based upon the state stipulation to limit this exhibit to
How
the
little
3
he is.
screenshots, I'm going to overrule or deny the motion in limine filed by Isaiah Chance. I find that the evidence the state seeks to admit that its probative
Look like
value outweighs any
saying to me.
prejudicial effect. Okay, and next would be the motions I have a copy of. Defendant Rashad Murphy's motion limine as to Robert Howard.
Ooh. Was it Rashad or Davion that he ran up on? Either one of the Murphys.
This is an all-encompassing motion, as the board can see, regarding several different areas. And it is buttressed on the statement provided and ultimately made confidential, made by Mr. Howard in August of 2025, as well as his deposition taken on February 4th, 2026. It seeks to limit, based on what I believe is hearsay, improper speculation by Mr. Howard, and pre-conspiratorial statements that are attributed to other defendants. Certainly understanding the court's ruling with regard to severance, I still have concerns about evidence that may in fact be admissible against one defendant and not admissible against others.
Oh, get on down.
Relates to the hearsay statements, Your Honor, any statements that Mr. Howard alleges Mr. Murphy made as it relates to threats to him or his family are statements that he heard from other individuals. And that's based on his testimony at both his statement and his deposition. He talks about things allegedly stated by Mr. Murphy that were told to him by others, and goes on to suggest that in his alleged conversations with Mr. Murphy on multiple occasions, he didn't consider those conversations either threatening nor friendly. So certainly buttressing that feeling and that speculation and that statement being what he's been told by others.
Okay, so maybe it'd be helpful if we just went through these statements. You've broken out the different statements per category, right?
Yes, sir.
So let's just start with the hearsay statements, beginning at page 2 of your motion. Specifically, you allege that Mr. Howard testified that he heard from other individuals that Murphy.
That music, that's the
Okay.
damn thing.
State, were you intending to elicit that from any, Mr. Howard?
Is this as to paragraph number 5, Your Honor?
It is.
No objection as to statements you heard from other individuals, only statements that Mr. Howard heard directly from Rashad Murphy would be suffered.
Okay, so as to paragraph 5, it's granted. And then paragraph 6, Mr. Howard further clarified that he spoke with Rashad Murphy on multiple occasions. Oh, so that's
That's just
different.
providing context.
Okay. And then the next would be paragraph 7. Mr. Howard testified, subparagraph A, that he communicated with Isaiah Chance, who told him that Murphy was hot about Adam's murder. State, are you seeking to elicit this from Mr. Howard?
Yes, Your Honor. Any statements that were made by any unaffiliated party.
I believe that man was alive.
As listed in this motion, the state's not seeking to introduce. But statements made by the defendant or co-defendants in this case, the state is seeking to introduce. Not as statements of hearsay, they're not being offered for their truth, but to establish intent and premeditation and motive in this case.
Okay.
Judge, it also goes to admissibility statements as it relates to Mr. Murphy. And the argument would be it's not a co-conspirator statement based on when it is said. And in fact, I think the state would have to establish when that statement was made to determine whether or not it was in the course or in furtherance of any conspiracy. And I don't think they can do that.
So state what your argument is as far as why this is admissible if the statement was made not during the timeframes of the purported conspiracy.
Because Mr. Gonzalez's argument reverts back to a co-conspirator admission, which is a hearsay exception. The state's position is that it's not being offered as hearsay. So understanding the limitations of a co-conspirator hearsay statement, we're not offering it as a statement of hearsay in the case. It is strictly being offered as proof of other elements, so knowledge, intent, premeditation. The state has filed in its initial response to the court and had previously provided to the court the case law on this before Mr. Gonzalez's motion. So the March 5th response gave the case law for all of the reasons that the state sought to introduce each of these statements, Your Honor, and we would rely on that case.
Okay, I'll come back.
Because Mr. Howard can't testify to what Mr. Chance told him about Mr. Murphy. And I don't think it's admissible based on any theory of motive.
Isn't it double hearsay?
The statements that Mr. Murphy was hot are statements that are made from Mr. Chance to Robert Howard telephonically. Is that what are these the ones you're referring to, Mr. Gonzalez?
Yes.
Okay. And so the state's not off, again, the state would just reserve the same exact basis as for why the evidence is being offered. It's not being offered for its truth. So continuing to indicate that because it's an out-of-court statement, it invokes co-conspirator hearsay when the basis for why the state is offering the item of evidence is strictly the defendant's knowledge of what was to occur, the premeditation of the act of what is to occur, because the context of that conversation is in telling the person listening, which is the witness, Mr. Howard, to be careful, essentially, when he goes to Tampa. these things are in context, being offered for a different purpose than a hearsay or co-conspirator statement or admission.
Let me think about it. Okay, the next one, subparagraph B of 7, Howard testified that Charles Jones told him to watch out for Murphy because of Murphy's purported threats.
No objection to the statement.
Okay, that one's granted. Subsection C of paragraph 7, Howard testified that he heard rumors that Murphy was riding past the prison that Howard was at.
No objection to the statement.
Okay, granted as to 7C. Okay. So I think that takes care of all of the statements identified in your subsection under hearsay. Is that correct?
That's correct.
Okay, moving on to opinion, speculation, beginning at page 3, paragraph 13. Howard testified about a Bill Belichick and Tom Brady social media post, which he attributed to Isaiah Chance following the murder. Howard speculated that the post referred to Charles Jones because Brady is the GOAT of football and Charles Jones is the GOAT of rap music. State.
The witness's impression or his specific observations, I don't expect he'll be testifying about what Isaiah Chance meant, but only about what he understood the post to be.
Judge, I think that's inadmissible. It's asking Mr. Howard to speculate, give his opinion as to what he thinks something might mean.
Well, what was
He's
the
not an
actual?
expert.
Yeah, what was the actual? What was it that was posted, and what was the content of the post?
A photograph, so it was not a part of our hearsay argument that we previously provided to the court of Bill Belichick, a coach of the New England Patriots team. There were consistent photographs of either Tom Brady or Bill Belichick posted by the defendants.
So Isaiah Chance posts photos of Bill Belichick and Tom Brady.
Yes.
Is there any words attached to the post or just the post?
No words on the Bill Belichick photo. I think hands up. I'm not sure how to describe the emoji, but an emoji on the photograph, but not words associated to that post. There were other Bill Belichick posts in the co-defendants' devices, so I have to pull them up to check for language. But to my knowledge, having discussed that with the defense attorneys, I didn't believe there was any other language that was on those photos.
And this was post murder of Charles Jones?
Correct. These were posted, some within minutes and some within the first couple of hours after the homicide.
Just for context too, Judge, some people may think Tom Brady is the GOAT of football. That's your opinion. Some people may think that Charles Jones is the GOAT of rappers, and that's somebody's opinion. And I think that that needs to be considered in its totality along.
Well,
with the other arguments.
yeah, I'm just trying to figure. And so what's it relevant to?
I believe if I'm recalling.
How about to say, where are we going with this one?
Testimony that was provided by that witness in trial 1 was that while he was on scene of the homicide within minutes, he logged onto social media, saw that post, and immediately knew that the poster had done it. Like that was the testimony that was provided. There was nothing specific as to the defendant's state of mind or what the intention behind posting the photo was. It was whatever the witness had observed on scene in that moment as he was checking social media and before they were able to notify the family or the media having arrived. That was the testimony that was received, and that's what we anticipate will be the same in this trial.
Okay. So within, how quickly did the post happen after the homicide occurred?
I'd have to check my timeline, Judge, because there are several across all of the devices that we have received.
Ma'am, come on. But how would he know unless it was just what he was feeling at that time? And would he have if it was posted any other day, would he have still felt the same? So I'm about to say that Tesla is the star of the show right now, and y'all worried about these little pieces of stuff like.
Isaiah Chance's post was on June 23rd at 6:13 a.m.
So is that the morning of the homicide?
Yes, Your Honor.
Before?
No, this is just after the homicide. So the homicide occurs about 5 a.m.
On June 23rd. So this is right after.
Ma'am, they bought this in the last trial. Don't act like you don't know.
Okay. So I'm going to deny the motion in limine as to the social media post. However, grant it as to any speculation on the part of Mr. Howard as to what Mr. Chance meant.
Judge, although I can't be positive, I looked at Mr. Petrini's screenshot, and it looks like the post was made on 6:13 a.m. And I think the murder occurred at 4:37 or 4:38, it's a couple of hours.
Yeah.
Hour and a half, 2 hours, somewhere in that neighborhood.
Right. So I've denied paragraph 13 as to the post itself, but granted it as to any interpretation by Mr. Howard as to what Mr. Chance meant by it. Okay, next up, paragraph 14. Mr. Howard testified that Rashad Murphy texted him after the murder stating, "I forgive you."
And Judge, what we're talking about is not a text that the jury would be viewing. It would be Mr. Howard's testimony that Mr. Murphy texted him and said, "I forgive you," and then speculating that that is a result of Mr. Howard having been convicted of the murder of Joe Rod Adams in 2018.
Okay, State, are you going to seek to admit this?
We are seeking to admit it, Your Honor, for the same basis, the motive and intent behind the defendant having committed this crime. The testimony from Mr. Howard is that that message comes in within either the same day or the next day. I believe this is testimony at depo and trial that he receives from the defendant.
He doesn't know when he got it, really, at the end of the day. Although he does limit it to within a day.
Okay, I'm going to deny as to paragraph 14, but granted as to any speculation on the part of Mr. Howard. Okay, paragraph 15, Mr. Howard further testified that, is that Rashad Murphy?
Yes.
Okay, spoke with him after the murder and that the two discussed their respective whereabouts. Mr. Howard testified that Rashad Murphy stated he was in front of Julio's car. Okay.
Yes, Judge. Mr. Howard speculated that what Mr. Murphy meant is that he was present at the shooting. But actually, Howard admitted that Murphy never stated he was present at the scene, nor that he participated in the murder. But the context of what he was alleged to have said was he was in front of Julio's car. He previously testified during his statement that in talking about the same discussion that Mr. Murphy alleged he was present at the Truth nightclub, not at the scene of the murder. And so obviously the inconsistencies are something that can be
sussed out in cross-examination, yes.
But as it relates to him testifying that Mr. Murphy was in front of Julio's car and then testifying that what Mr. Murphy meant was that he was at the murder should be limited.
My only concern with this one is it gets a little bit convoluted. It is a part of the conversation that Mr. Howard is indicating that he's having with the defendant, whereas the defendant is completely describing the scene. You had your head on a swivel. You were looking here and there at each of the locations. And so certainly the state is seeking to admit it as identification, but I think this one, if the court is inclined as it relates to the speculation, maybe one that we ask if the court would allow that we wait until we get to that point in the presentation of the evidence. I don't know how we can slice that up, if that makes sense, based on the context of the full statement that he gave for that.
I just don't want during the course of direct testimony for Mr. Howard
To draw an opinion.
to speculate that what Mr. Murphy's talking about is he was in front of the car during the course of that murder.
Okay. So again, I'll deny paragraph 14. It's admissible. But again, Mr. Howard cannot draw opinions. He can only testify as to what was said. And then that's why we have closing arguments, and you guys can argue the meaning.
Did you say 14 to 15?
I'm at 15, yeah. All right, paragraph 16, Howard also testified that Rashad Murphy later told him, "It is all good, we good now." State, are you intending to introduce that statement into evidence?
Yes, Your Honor, but no objection as to limiting without speculation on the part of the witness.
Okay, very much. Very good. Then the paragraph 16 will be denied. But again, no speculation or opinion as to what Mr. Rashad Murphy meant. Okay, paragraph 17, Howard opined that social media posts referencing Don Julio were intended to disrespect toward Jones because Julio appears in Jones' Instagram handle. State, were you intending to solicit that opinion from Mr. Howard?
Not as it relates to disrespect, as it relates to Don Julio or Julio. If he has specific knowledge in this case about the fact that Julio and Don Julio are linked because of his relationship to the case, I would ask that that be admissible.
And Judge, I guess, just for clarification, Mr. Howard's not going to be testifying to his opinion that it was done in a manner of disrespect.
Right, he's just going to say that
I saw bottles of Don Julio.
and to me, and based upon my knowledge and experience or whatever it may be, that is a reference to Charles Jones, right?
Understood.
Okay, so it's denied with that understanding. Again, as to paragraph 17, Mr. Howard can testify as to the facts or what he knows, but he can't speculate on the intention of the poster. Okay.
It's the end, Judge, of those that.
Okay.
category.
Moving on to co-defendant statements.
And again, I'm going to preface before the state goes any, the court goes any further. Again, understanding the court has ruled
Right.
as it relates to severance. I just want the record to be very clear.
Yes, you're
Still
not,
have concerns.
yeah, you're not waiving any objections that you've previously made. Okay, let's see. Paragraph 25, Robert Howard stated that he had multiple conversations with Isaiah Chance in which Chance expressed his dislike for Charles Jones. He emphasized that Chance and Jones engaged in multiple social media arguments in which they disrespected one another. Are you going to be attempting to admit this evidence via Mr. Howard?
Yes, Your Honor, all of it will come in through the experts, except for one interaction which occurred between Chance and Charles Jones that Mr. Howard was the primary witness to. Otherwise, law enforcement witnessed the exchanges.
And certainly my argument has to be, notwithstanding other motions and other rulings, is that Mr. Howard not testify to that. It's coming in through a gang expert.
Right.
And as it relates to his direct interaction in seeing something occur, then of course I don't have a legal objection to that.
Okay. So it's a paragraph 25. It's sort of a general argument. I'm going to deny the motion in limine as paragraph 25. However, you reserve the right to make contemporaneous objections at the time of trial. So if something's coming in through the gang expert, then at that time, if you want to raise an objection, you can, but generally speaking, it's denied. Okay, and then there's a more specific statement at paragraph 26. According to Robert Howard, Isaiah Chance allegedly stated that Charles Jones was going to die. Do you seek to admit this through Mr. Howard?
We seek to admit the conversations that occurred within the time frame of the conspiracy that's listed as it relates to these conversations, but not from before that. The motion, though, is not clear because there were conversations which occurred outside of that time frame discussing the same type of comments or threatening remarks. Mr. Howard and Mr. Chance had some type of relationship which was jovial enough for them to speak often about this issue, but there are specific exchanges which occur which indicates that there are threats on the victim's life and for Mr. Howard to kind of avoid that danger when they come to Tampa. We know that's within the time frame, regardless of whatever testimony Mr. Howard was able to give in his deposition about the specific dates, because they reference the posts that Mr. Jones made to social media of the flyers for the events that were occurring in Tampa, and that occurred on June 14th of 2024.
Judge, I would only point out that certainly we have to rely on Mr. Howard's testimony as to when he heard these things. We have no other way.
I know.
And to the extent that he testifies under oath that he believed that it occurred at the end of 2023 or beginning of 2024, it would have been long before any conspiratorial timeframe. And again, as it relates to Mr. Chance, that argument can be had in another way. So generally, it occurring within late 2023 or early 2024 is a problem. And again, I would reiterate, as it relates to evidence the jury's going to hear that they can consider against Mr. Murphy, it's a problem.
Okay. So there's two separate things going on here. So let's first discuss, if I'm hearing you correctly state, you're only intending to seek these conversations between Mr. Chance and Mr. Howard during the time frame of the conspiracy, correct?
Correct. The content of the conversations during that time frame.
Okay.
Otherwise, it is just generally the relationship between the two. Did you speak on the phone previously?
Right.
What was your relationship, but not the content?
Not the, okay. So with that understanding, that's what the state is saying. So it would appear then as to paragraph 26 and 27, because Mr. Gonzalez is alleging that Mr. Howard stated that this specific comment that Charles Jones was going to die occurred sometime at the end of 2023 or the beginning of 2024, which would be outside of your conspiracy timeframes, correct?
Agreed, Your Honor.
Okay, so as to specifically paragraph 26, that will be granted. Paragraph 28, Howard further testified that the ongoing dispute between Charles Jones and Isaiah Chance had escalated to the point that if they would have seen each other, they probably would have wanted to do something to each other. That appears to be Mr. Howard speculating. Are you going to seek to introduce that?
No, Your Honor.
Okay, so granted as to paragraph 28 is that statement. Yep. Well, 27 is not, it's just a historical fact. Okay.
The finding though, Your Honor, if I may, as to 27 and 28, they really should be together because the other remarks about Mr. Jones dying do occur within our conspiracy time frame. So I don't want the record to be unclear. There are several remarks made within our conspiracy.
Right. So, okay. So as to 27, it's granted as to anything outside of the timeframes of the conspiracy, denied as to any statements made during the time frame of the conspiracy.
And certainly, Judge, subject to later potential objections, I would certainly having no reason to dispute what Ms. Isber saying. The state's going to have to, in order to admit those statements, lay a foundation as to when they occurred and whether they occurred within the conspiratorial time frame. Anything that Mr. Howard can't tell us when it happened, if that turns out to be the case, certainly I think should be excluded.
Okay. Yeah. So again, subject to contemporaneous objections at the time. That the appropriate foundation needs to be laid. Okay, paragraph 29. According to Mr. Howard, Davion Murphy confronted him regarding Howard's involvement in Adam's murder and stated, "Bro, I'm going to catch up with you. I'm going to deal with you." This allegedly occurred at least 6 years prior to the conspiracy. State, are you seeking to admit this?
We are seeking to admit it, Your Honor, for identification purposes and for motive evidence. These statements were made specifically as a part of this quote as well, following Mr. Murphy's mention that Spaz, or the person that Mr. Howard was incarcerated for killing at the time, was his relative. And so he's shouting that at Mr. Howard at the time. Mr. Howard also being present with the victim in that parking lot on this evening would be a basis as to why we're seeking to introduce this.
Okay.
It occurred allegedly 6 years prior to Mr. Jones' murder. Number one, again, just so we're clear, there is problem number one, its admission of a statement 6 years earlier and how it might affect the jury as it relates to Rashad Murphy, since we are not severed, number one. And number two, it again falls, based on the prior arguments, far outside of the conspiratorial timeframe.
All right, let me think about that one. Reserve ruling. Okay. 30 is just a statement of law. Paragraph 30.
One more thing, Judge.
Sure.
Also, as it relates to the fact that there are two Murphys here, and these Murphys are cousins.
Right.
I think there's a even more complex and complicated issue in allowing that statement to come in and how the jury may perceive it, and its prejudicial effect outweighing any probative value.
Okay. Thank you. I reserve ruling. 30, paragraph 31, Howard attributes several statements to co-defendant
Can we
Isaiah
talk about,
Chance.
Judge?
We've already discussed it. Okay, same ruling. 32 is just a legal
Context,
argument. Okay. I think that takes care of
It
your
does,
motion. Okay, so I'm going to think about
7A.
7A and then paragraph 29. Okay, I'll let you guys know.
Thank you, Your Honor.
Sure. And again, when we talk about the severance issue, again, just to clarify, we don't have a brutal problem here. And then the only issue would be if there's evidence that would, quote, improperly influence, close quote, the jury, with evidence that would be admissible against one or more co-defendant and not all of them, which is kind of an amorphous standard. So it's kind of beauty in the eye of the beholder. So that would be the determination, whether that evidence would rise to the level of improperly influencing the jury.
And Judge, it goes without saying that the state would not.
I'm gonna go without saying, and you keep saying.
Limiting instruction from this court, specifically with instructions to the jury as to which defendant the evidence applies to at the time when we introduce those portions.
Sure, I understand. And it is a different, I did find really an abundance of caution. The two statements or the two text messages that the state agreed not to introduce were I think it was 2023, a set of text message exchanges between Isaiah Chance and Alicia Andrews. While those, in my opinion, are admissible as to Miss Andrews and Mr. Chance, it does predate the conspiracy. So in abundance of caution, those should not come in. The state agreed. The other one was, I guess, the celebratory comment made by Mr. I think Davion Murphy that was sent to Sean.
Judge, I don't believe we know which Murphy
Right.
specifically sent it, but it's
Okay.
signed Murphy.
Right. So for those reasons, and including the fact it was post-conspiracy and an abundance of caution, I didn't think it should come in as at a joint trial, and the state agreed. These statements that are made by the defendants during the conspiracy timeframe in particular are distinguishable from those that I thought should be excluded in an abundance of caution. As I'm trying to not tiptoe close to, quote, improperly influencing, close quote, the jury, as that phrase has been utilized in specifically second DCA precedent. Did they use it against you before?
The court's ruling as it relates to the celebratory messages that are not coming in. There was testimony from Detective Ramos that, in fact, the witnesses he spoke to indicated that they didn't know Rashad Murphy. It was Davion Murphy that they were aware of, and that's who they believe the text messages were sent by.
Right. So we had two issues with those messages. One, it was post-conspiracy, and two, the foundation of who actually sent it, which of the Murphys is less than crystal clear, right? Right.
Okay. Okay. So, and then the other motion was with regards to the Andrews verdict during penalty phase.
Yes, Mr. Harmon filed that, I believe yesterday afternoon. He is out today, but I said that I could cover it. Do you want to handle that now, or I don't know if you received it or not?
Baby, don't say
received
nothing
it.
about her. She
I
wasn't
haven't
in my
seen a copy
case.
yet. So do you have a copy I can look at?
And what happens if that gets overturned? Don't talk about her. She wasn't with us. She wasn't with us. Because if they're able to use those.
Okay, thank you.
Because the other scary part is they're naming Chance as the mastermind.
Mr. Petratus had filed a judicial notice of the verdict of Alicia Andrews, and we had spoken, and I think that you had previously said that obviously would not come in during the guilt phase, and it did not have a relevance. I think that Mr. Petratus had made some indication that he thought it might be relevant for penalty phase. And I think that is Mr. Harmon's objection. He filed a formal motion in limine objecting to that as it would be improper and have no bearing or relevance to the jury's decision with regards to mitigation. It's improper character. There's no reason or way to tell this jury why the jury in Alicia Andrews made the decision that it did. There could be a myriad of reasons, including mercy, jury nullification. We don't know why they made the decision that they did. So what happens in one defendant's trial, verdict, or sentence doesn't have a bearing or should not have a bearing.
It's the other way. The state don't want that. Now that's a good one. That's a good one. The state is saying they do not want the defense to be able, if we get to a penalty phase, they don't want the defense to be able to mention that Alicia Andrews only got manslizzy. That it wasn't no first degree, it wasn't premeditated, it wasn't none of that. That they talking the jury before you said manslizzy. That may be the biggest mitigating factor. If remember, I said it. It didn't make no sense because what they did to that boy was not manslizzy. That was premeditated, but now it's coming back to bite them in the butt because now think about this. We know that Alicia Andrews currently has a motion in that literally says, "Hey, judge, new judge," because we got rid of that old judge. That verdict they gave, neutral us. Throw that out because that verdict that they gave don't match the evidence and it don't match the law. It don't match the weight of the evidence. Throw it out. Now I know the defense is saying that on account of it don't match the evidence, it don't match the law. So because if that's the case, it should have been not guilty or it should have been all the way first degree. But if they're holding on to use this as a mitigating factor for them and then the defense gets it thrown out for Alicia, then what does that mean?
Defendant's penalty phase.
Oof.
And so that was the basis.
They still crisscross applesauce.
Well, it looks like there may be precedent, United States Supreme Court opinion, Lockett, right?
Yes, there was some case law that he filed as well.
Okay.
In support of his position.
Okay, so I tell you what, I'm going to take it under advisement. Let me take a look at this Lockett case. And then, Mr. Petratus, do you have any additional, or does anyone have any additional case law, or do they want a chance to submit it?
You said that boy.
Okay, so I tell you what, I'm going to take it under advisement. I'm going to look at Lockett.
Could we have a chance?
Yep. How much time do you need?
Briefly address something on that.
Sure.
I just looked out the motion this morning, but I think we're just dealing with sentence, not involvement, correct? Because
Correct.
I think that Alicia Andrews' involvement in a penalty phase can be compared to a particular another particular defendant's involvement. But I'm trying to make sure that the state's motion is only dealing with sentence, not Alicia Andrews' actual involvement in this case.
Well, it says specifically in the motion, the subject matter in question is any argument comparing or regarding the verdict rendered by the jury to the Alicia Andrews case to the defendants or otherwise arguing that fact as mitigation.
The point, exactly, the point I'm making is that I think that her involvement, any defendant's involvement, which can be a problem when you have multiple defendants, but the involvement of one defendant versus another can be relevant for a penalty phase.
Okay.
Not verdict, as in the Andrews case maybe, or the sentence, but certainly one person can be more culpable than the other. And again, the problem is suggesting that maybe one defendant should get life and another defendant should get death.
Okay, so I'm going to give you guys a chance to research the issue and submit case law. Okay, so how much time do you need?
At least a week.
Sure. Okay, so I tell you what, I will give you guys until Friday, April 10th to submit any case law to me on this topic.
Yeah, buddy. Pointing fingers. And I figured that was going to happen anyway, because at the end of the day, what Isaiah Chance can always say is he wasn't there. And the fact that they actually pointed out Isaiah Chance's gun in
Any
a
other
trial, but in this trial, his gun is not relevant. He was gone.
Your Honor, as a part of the state's response from this morning, the court had previously asked the parties to submit to the state any additional YouTube videos they intended to use or additional items of evidence that the court needed to consider. So the state did also address those things. I can tell the court that I've reviewed the videos that were provided, and the state does have some objections to those videos. I know Mr. Chance, on behalf of Mr. Chance, that there were 4 videos provided, and on behalf of Mr. Murphy, there were 4 videos provided.
Davion Murphy.
Davion Murphy. I will defer to the court as to how we address those, or if the court just wants to hear the state's objections as to those.
But do you have them identified?
Yes, and with a link in the event that the court or the other parties wish to see that as well in the motion.
But you haven't filed a motion in limine.
I have filed a motion, yes.
You have?
Yes, Your Honor.
Okay.
I filed it this morning because we received the defense to this motion in limine on their yesterday.
Okay. Well, can I take a look at your motion?
May I approach? Your Honor?
Sure. Okay. Okay. All right. So according to this motion, state wishes to keep out, as to Isaiah Chance, a video titled List of Dead Ops that was posted on YouTube.
Why would you?
A block party invasion went to Young and Ace block. It's a YouTube video. 3, God Don't Know by Julio Foolio. And number 4, Demigod by Julio Foolio. So are any of the defendants seeking to actually introduce these, and why?
These would be, these were said somewhat in abundance of caution, but these would be rebuttal, depending on what is testified to by some of the state's experts, the gang experts.
I see.
And it, they would be authenticated through that expert, if at all. It may not be necessary depending on direct cross-examination. And possibly only if it needs some still shots from some of these videos.
All right, so you're not intending to utilize these in your case in chief, seek to admit them in your case in chief. It would just be potentially as impeachment or rebuttal as to the testimony of the gang expert?
Correct, Your Honor, for a variety of reasons, based on gang certification and issues with Mr. Jones.
Okay, so then as to these 4 identified videos, I'm going to grant the motion without prejudice to revisit. If you think that you actually need to introduce them, we just need to talk about it before you do it.
Yes, sir, I understand.
Okay? But generally speaking, the videos are not to be referenced or discussed in front of the jury until I've given permission for any party to do so. And then as to Davion Murphy, the videos listed are When I See You by Julio Foolio. Again, the list of dead ops, YouTube video, Certified Killer by Julio Foolio, and God Don't Know by Julio Foolio. And why is Mr. Murphy going to seek to introduce these, or what are you going to do with these?
Would be in the same position as Mr. Chance becomes.
What we're trying to do-
If you think they become relevant, then you would seek to introduce
That's
them.
correct. That's court just to,
But you're not going to be submitting them as you don't anticipate at this point as part of your case in chief.
correct.
Okay, so that'll be the same ruling. Generally speaking, these videos 1 through 4, as to Davion Murphy, the state's motion is granted. However, without prejudice, to revisit, and during trial and defense, you just need to confirm with me ahead of time before you start showing them or discussing them in front of the jury.
That's fine.
Okay, very good. Then we've got unrelated officer conduct. Counsel for Davion Murphy has filed a notice of intent to rely and listed a witness and records from the Jacksonville Sheriff's Office to include the personnel history of Detective Craig Griffin and Trey McCullough. Are you going to actually seek to utilize these records as impeachment?
Yes, I believe that's Ms. Jemay's motion.
She filed a motion as to these?
Yeah, I thought that was what it was. Correct.
Well, 'cause I don't have that motion in front of me. So
Yeah, they did play some of his videos.
Janae, did Davion Murphy file a motion?
Definitely the When I See You
specifically
and
to
the
include
one.
this information?
She did not. She said
But
this
who
was
I
all
smoke-
the notice of her intent to rely on the information, and she did file an amended discovery list with instructions that she would seek to introduce or admit the following videos and evidence, and then listed the witness as well.
Okay. So, Mr. Sonardi, is Ms. Tomei, is she handling this argument, this issue?
I was not aware that Ms. Jemay was not going to be here. I'm really not in a position to argue that motion.
No, I understand. I honestly would like to see what we're talking about here, as far as what the actual evidence is. So,
They were not filed, Your Honor, but I do have 2 copies of the investigation history. I do not have copies of the civil lawsuits that were filed against the Jacksonville Sheriff's Office for the court because they were pretty lengthy. But I can provide these copies.
But I don't think that was actually filed.
okay. So here's what we need to do. Are you able to contact her this morning, Mr. Sonardi?
Right. I got her number on me.
The police officer guy? Did he just get out?
Your Honor, if it's okay, I have, warrant in Polk County if I can.
Yes, you're free to go. So I tell you what, let's do this, Mr. Sonardi. Let's just take a. We'll
You gotta go
recess
somewhere
as
else.
far as
Take my ass
Davion
down. They're trying to
Murphy,
kill me.
because we're going to
no.
use another date. because I'm going to need to actually physically take a look at what these records are. And we need to have further discussion on this, and whoever needs to be able to argue the motion. So why don't you find out her availability for the remainder of this week and Monday and Tuesday of next week, so we can get that done. Are there any other issues as to Rashad Murphy, Sean Gathright, or Isaiah Chance?
The only thing, and this may not be the time, but I know we were talking about deputies. They want to talk logistics as far as how we're going to plan on fitting everyone.
I was gonna bring that up, Jeff. There's a small army on the side of the fence.
That's
Okay.
only about half of us, I think.
Okay,
What the hell? I just,
well,
You're just gonna leave that up to us and the court staff?
yes.
Do you have anything you don't want? Because
No, I really don't. As long as you guys can get to the podium without having to create a distraction, that's all I care about. So
and certainly having ingress and egress without
yeah,
the staff being concerned about.
correct. So I do think anybody that's not going to be speaking on the record, okay, staff that's not going to be speaking on the record, do you want them in the well, or are they okay in the audience, or what do you think?
Judge, in previous experience, I could tell the court that for me personally, my investigator is critical.
Okay,
In a number of different ways in a trial this big.
okay,
So I would suggest to you that I would need my investigator at council table.
okay. So how many people total? You have yourself, Mr. Hernandez, your investigator. Who do you need at table in addition to your client?
Mr. Hernandez, myself, and the investigator.
Okay, so you need 4 people.
Correct.
Okay, Mr. Sonardi, how many people do you need at council table?
Your Honor, obviously, myself, I'd like to have my investigator, but it's possible that she could sit behind me, so she's not. at the
Okay.
table.
Could your investigator sit behind you, Mr. Gonzalez?
I'd rather not, Judge.
Okay,
I mean, unless it's a crisis situation, because he does work very closely, not only with me,
Okay.
but with Mr. Murphy.
okay, so they want,
And I would like Scotty Sonardi, the other.
Yes.
attorneys with me.
and Mr. DeLauder.
I don't know.
Your Honor, I'm considering I'm the smallest fish in the pond and the last one on the totem pole. I'll go wherever I need to facilitate.
You could-
It'd be nice to be at the table,
Right,
but wherever I.
need be, we can throw you off the island into the audience, right? Okay, but 5 preferably in a perfect world. Okay, Mr. Wise?
Here we have Ms. Finkelstein, you may recall Mr. Mendez is third chair counsel as well. He's been here for some of the proceedings. And then I would like our investigator slash mitigation expert, at least during jury selection, if there is a definitive phase.
Okay, so 5.
Yes.
People? Okay, Mr. Petratus?
5, Your Honor.
5.
But we can have at least 1 or 2 times.
Okay. Okay. Ooh, okay. Okay, very good. So we are,
Not very good at math. I think that's 19.
yeah, okay. That's fine. We'll figure it out. Maybe we need to change the setup as opposed to an L shape, because once we get the jury in here, it's going to be much more important that you all are facing the jury than me. So what I may do is have the bailiffs, we'll work on it, but maybe move the table so they're actually facing the jury, and during jury selection, turn them so they're facing out towards the jury, something like that. Okay, so we'll make it work. We'll figure it out.
Your Honor?
Yep.
Hi, I'm Nixon, I'm the investigator. I have Deborah, told me, she said she is available April 2nd in the afternoon at 1:30.
Okay, state.
Does that work for you?
It is for me, but I don't know, does it work for the state?
Sorry, what was that?
April 2nd at 1:30.
I could, could we make it 2:00?
Okay,
Okay, for the state.
Okay,
I will say yes, on behalf of Mr.
all right. So, and then as to,
And I also think, just from speaking with Ms. Toomey and myself, there's one other matter that we may not be in total agreement about, the defendant's reported statement that she may want to bring to your attention. We have worked out most of it.
as to Davion Murphy.
Yes, ma'am.
Okay, that's fine. So I will hear those matters at 2:00 on April the 2nd. If the other defendants wish to be present for that. You're welcome to. It's up to you. Mr. Gonzalez.
Oh, nothing further, Judge, and thank you for the offer. I'm not sure we'll be attending, but
Yeah, that's fine. So for now, I'm going to tell the sheriff's office not to transport your client, but if something changes,
that's fine, Judge, yes.
okay. So do not transport Rashad Murphy on April 2nd in the afternoon. As to Mr. Gathright, Mr. Wise, does your client wish to be here for those motions?
I have a conflict, Your Honor. Mr. Gathright is fine with waiving.
Okay, that's very good. So do not transport Mr. Gathright. And as to Mr. Chance, Mr. Petratus. Okay, very good. All right. Davion Murphy. Okay. And that is so that I can hear I know you just gave me the motion. I know you just gave it to me. Now I can't find it. The motion with regards to the personnel files of two of the detectives from the Jacksonville Sheriff's Office.
And any objections from the defense if we just as a courtesy, just print out the exhibits that were provided to the state and hand deliver them to the court at some point today? The attachments that were all sent to us with this personnel file, those lawsuits and such, everything we attached. Is there any, sure. Is there any objection to us providing that in advance to the court for review before Thursday?
No.
Okay, and for the record, it's the state's 7th penalty phase motion for order in limine. No, that's the.
Yeah, that was the one.
Yeah, that's the one I gave you all until gave April 10th to the defense to submit any case law. Oh, okay. So it would be, we're going to, as to Davion Murphy, the motion for, it would be part of the state's motion for order in limine regarding improper character evidence as to unrelated officer conduct. That's what we will hear Thursday, April 2nd at 2:00. Yeah, let's just go ahead and use in my regular courtroom for that since it's just one of the defendants. All right, so please let Ms. Toomey know, Mr. Sonardi, that I'm going to hear that motion in my regular courtroom. Okay. Okay. Is that it for today? Oh, and on the raw data, I need, how quickly do you think, how much time do you think you need for your experts to get that information over to the state's expert? A week? What are you asking for, state?
Judge, I think that as long as they get it to us within the week, I think that should give Mr. Harmon's experts the opportunity to be able to review it. I don't believe they have set Mr. Harmon's expert witness for deposition yet either, so I think that that's fine.
Judge, I probably should not let Mr. Hernandez go, but, and I don't, because I don't know the status of the way that train is rolling, certainly I'm going to just defer to whatever the court thinks.
All right, I'm going to say by April 8th, by the time we begin jury selection. Okay?
Judge, and just that reminds me, I know that Mr. Petratus listed an expert, a gang expert as well, that we attempted to take the deposition of, but that expert is Dr. Leap, had not actually finalized her opinion, and she said that she would have it finalized by the 8th, and we would be able to take her depo in a couple of days from that time frame. I just wanted to put that on the record just to make sure that
she has her finalized opinion by that date.
Let her know, we scheduled it for April 9th at 5:30. And I let her know that, she responded, she's under the weather right now.
Okay.
Won't be a problem for April, but I did let her know that demo date, and she has
Yep.
sent me a pushback.
So that, what's the expert's name again?
Dr. Leap.
Leap?
Leap.
Okay, Dr. Leap's report needs to be submitted to the state by Okay, 9 a.m. on
Oh, I'm about to say now. Come on now.
Oh, is she gonna, does she have any material she's gonna rely upon?
Yeah, she's relied upon,
The state's
the state's
evidence.
discovery.
Okay.
She will, but by the depot date, she will, when she
Okay.
gets the depot, she will have to have it.
Okay, so she's not gonna issue a report, so,
That's
But-
perfect.
okay, very good.
Does I have a question?
Yep.
The state's motion regarding the improper character evidence.
Yep.
As to that, right?
This just says to Davion Murphy.
Right, because I thought you had said it was,
Well, no, part of it was.
part of it.
So I've ruled on the motion for order in limine regarding improper character evidence and the state's response. I ruled on the video portion. Okay, that's I've ruled on. I've granted the motion without prejudice to revisit if necessary. And then unrelated officer conduct as to that part of the motion, that's being set for hearing or continued for hearing for
Okay.
April 2nd. Okay? Okay, and I'm gonna hold on. Ms. Ismer, you gave me a copy of the state's response and motion for order in limine regarding improper character evidence. I'm just gonna hold on to that. That's okay. Okay. Anything further? Okay. So, if you don't hear further from me, or if you do need anything, by all means, make sure you contact me and let me know. I'm available to do whatever I need to do to help you guys get ready for trial. So for those other than Mr. Davion Murphy, if you don't need me in the interim, then I will see everyone. You need to be, I would say, courtroom 1, I would be there by 8:30 in the morning. So as soon as jury services gets 175 people to walk through the door, they will send the list over to us with the names and numbers. You guys can begin filling out your seating chart. Okay. So be it in courtroom
Name and
1.
number only, we're not
Only.
on jury sheets.
Yeah, because at least half of those people are going to be gone by the end of the day. So there's no point reviewing juror slips for people that are going to be discharged. There's no reason. So, and then you'll have more than sufficient time to, you'll have over the weekend to begin reviewing the slips for any and all that are coming back for phase 2 voir dire the following week. Okay?
But we'll be trying to piece in here, just jury selection. on
Correct.
one.
Just jury selection in courtroom 1 because I need the lobby. Okay? Okay. Very good. Thank you all.
All right. So that is actually it for the most part for the motions. They still have some stuff to work out for Davion, but apparently it has to do with Davion and Davion only because everybody else is willing to not show up and let them finish working that out with statements made by Davion Murphy and motions in regards to that. So that is all that we have for today. But for tomorrow, we have 2 possible things, but definitely 1. So tomorrow should be, or is supposed to be, the scheduled sentencing for Judy Church. Now, wow. We got to be real about it. A conviction of first degree unaliving with hers was like with premeditation and extreme cruelty or something of that nature. Carries a mandatory sentence of life. it's a LWOP. But we do know that the state and the victim impact statements, there's probably going to be something said, a thing or two by the judge, things of that nature. But we know that the sentencing hearing for Judy Church, who was found guilty on Monday at first degree premeditated unaliving of her long-term boyfriend, Leroy Fowler. Her sentencing is tomorrow at 10 a.m. Eastern Standard Time. So we will be up and ready for that. Oh, Keisha, she knew what she was doing to that man. She knew what she was doing to that man, and she was being funny when she did what she did to that man. She absolutely did. But her sentencing is tomorrow. Now, as we heard, also one last final motions hearing before they get underway. So as you heard, Judge Sisko is moving forward. She's keeping the train moving. They are headed straight towards trial. Starting next Wednesday, like a week from today. So tomorrow will be the last little bit of or motions for Davion Murphy. That is to begin at 10 p.m. Eastern Standard Time. I said 10 p.m. What is wrong with me? 2 p.m. Eastern Standard Time will be the rest of the motions that need to be sussed out for Davion Murphy. After that happens tomorrow, anything that need to be said or done is like a speak now or maybe not so forever hold your peace, but get it done before Tuesday. Because as of Wednesday, they're going to start bringing in those 150 to 175 people, and they're going to start trying to get them a jury. And then once they get those 150 people narrowed down, get folks kind of sussed out based on whether or not they believe in the final destination penalty, or whether or not they will have a hardship, or this will be unduly hard on them to have to try to maintain their life and be a juror. All of that will be sussed out by Friday. And the folks that come back on Monday could possibly end up in this jury. Again, they're trying to get this all taken care of so that we could possibly be seeing opening statements by April the 22nd. On or before April 22nd, it depends on how quick they get a jury for this. So, as we know, there were 5 defendants in the unaliving of Charles Jones or Julio Foolio. We know that our first defendant and the one and only female, Miss Alicia Andrews, who was dating or seemingly still in a relationship with Mr. Isaiah Chance. Her and Mr. Chance, it looks like they're went after Alicia the way that they did. If they truly believe that Isaiah Chance was the mastermind, that's why they went after Alicia like that. Because we know you knew because he put all this together and you be in his skin. But the state is in a unique position because while they didn't have all of this evidence against Alicia, because of course some of it would be completely inadmissible, they did get a practice run on presenting this with Alicia. They're absolutely not happy with it, as we heard, because they don't want nobody to tell nobody about the fact that she got this man slizzy. But we know that Alicia's defense team is working on a new trial for her. They feel like the weight of the evidence itself and the law does not support the conviction that she got. So they're working their way backwards. They got the judge taken off so that she could not sentence her. And then they said that you sentence her on what? Because that verdict don't make no sense. So we're waiting on, I believe they have to make their last in a second. They have to make their, I believe, last case on that, or last argument on that, on April 10th. So we'll keep an eye out for that and see what's going to happen with Alicia Andrews, if they'll move forward with her sentencing or if they'll give her a new trial altogether. Then we'll see if Isaiah Chance, now being named as the mastermind, along with Rashad and Davion Murphy, and then Sean Gathright, if they will not only be found guilty, but if that guilty will lead to them being executed. So this is going to be a bit for pre-draft affairs and getting shenanigans here that week. 21st through the 26th is going to be a mess. I feel it. Ooh, the draft, yeah. Well wishes to all. All right, guys. So that is it for today. Y'all know Wednesdays is my early day because them kids will be home about 30 minutes. What about Thug? What about... Do y'all ever feel like stuff happened at the worst possible time? I think stuff happens at the worst possible time. Because Thug is not the only person from that indictment. They got some shiggity going on right now, and I'm not going to be the first one to say it. But there's other people that got other stuff going on. And I just feel like if everybody goes in front of Paige at the same time for some bullshit, like probation at the same time, everybody got probation, she gonna get mad at somebody like, oh, y'all motherfuckers is acting up. You know, back in the day, your mom, if she whipped one, she whipped all of y'all. And so I just like this, the worst possible timing with the worst possible person is what I believe. I wouldn't be well, y'all got to remember, Charleston White took a very, very strong stance during that YSL trial. I would have never been in the same room with him. Even if he told me, oh, I see that you did this, and so you got things that, God, you see that Judge Whitaker is adapting to certain things as things happen. Like Thug had the whole issue where the post was made about Viverito and the DA's office being liars. And then all of a sudden after that, the next person who got a plea deal had in their plea deal about social media posts. Nobody else has that. So they're like adapting to what is happening to kind of rein in and put a tight leash around everything so that if anybody wiggles free out of that leash, it's going to be a problem. They're going to probably hang themselves. So I just find it very, God, you got to be more careful. You got to be more aware, because that man is very aware of what the basis is for what he needs to do. He knows that he can't say for sure whether or not somebody had a popper. If they had a popper, he can't say he saw a popper. He can just say somebody clutched near that area. But all he has to do is have a belief that that was it and have a fear. We've seen it all the time. And I hate to say it, but that person actually uses the same tactics we hear when we watch a case about a cop who has popped somebody and they were in fear of. He knows exactly what wording to use. And he had a very particular stance on that case. Yeah, he aligned himself with people. And again, I've always said, that case had victims. There are people who are no longer here. It's just the way the case was tried was not okay. But there are people who left out of here. And I know folks got mad at me when I did it way back when I actually lined up all of those incidents of popping back and forth and how they were happening two within the same hour, then back over here, and how all of that happened. And somebody said, you doing the prosecutor's work. But it was like to understand why those cops were saying they weren't getting sleep and why they may already have in their mind, like, y'all playing games here, just put them in jail. Charleston White aligned himself with the family of the main victim that we talked about for about 100 days in that case, right? He emphasizes certain words when he describes what happened, and he knows he's emphasizing the words that would be in the charge that he's looking to get, the charge that he knows could be given, and he emphasizes the words that will make the case every time. And just regardless of how you felt about him, just seeing the way that he handled Woody, just seeing the way that he handles other people, when he makes his mind up about what's right and what's wrong, he is very persistent. He is very goal oriented. He is, he's got a focus. Okay. And then he's also got the patience of Job, and he will get the last laugh. He will do what he can, what he will. And the sad part about it is very rarely, I can't even say rarely, he knows what to say. So nobody can say he lying, ain't nobody had no gun. He never said nobody had a gun. You see what I'm saying? Like he knows what to say. He knows what to say. And knowing that we have those, I said it in my video the other day, those guys have decades of probation ahead of them. I know there are ways that they can get off early and XYZ, but we are not there yet. They have decades. And the way that I see it, I made the kind of the analogy or inference the other day where they could have a grandkid born today, make it 18 years, and be at that grandkid's high school graduation, cut across the street, get a jaywalking ticket, and their new probation officer will be somebody that's in kindergarten with Denver today. Right? Like, it's so much time, like, and something like this can be. I just hope that they still know he's an entertainer. Brian Steele was very, very, very meticulous about crafting his probation, going back and re-asking for certain wording to be in there and getting that granted. Not because he was asking for him to get off. We were all like, just ask for him to get off. Just ask for him to get off. Brian Steele never asked for him to get off. Brian Steele just asked for it to be crafted so that he could have a chance. And also, one of those things that Brian Steele crafted was so that he could actually still be around poppers as long as it was professionally licensed security. So I'm hoping that whoever the tubby guy is that this man is talking about, that may or may not have been ready to secure some shit, that was licensed professional security. That is got to be that's got to be what's happening. He has to have that level of people with poppers around him. He's got to pay for it. He got to pay the invoice. If that's who was with him, sorry, Charleston, if you were talking stuff to him and his security felt like you was being a little, then that's it. That's it. But if that person was not a professional licensed security, if it was just a homie, you're doing what you did in the beginning, and I'm going to be pissed, but that's a grown-ass man, dog. That's a grown-ass man, and I hope he understand that people like that made it very clear how they felt about you when you were standing in there long before you even knew that plea was going to be a possibility. He made it very clear who he stood with and how he felt about you and anybody else around you. And I wouldn't be in the same room with him. Call me whichever you want. You can call me any word you want to, but I would have locked myself in the bathroom stall and have my security stand in front of that bathroom until my plane was ready. I would have covered my head and walked and not made no eye contact. I would not have wanted him to know that it was even me, because there is no way, shape, or form that I know somebody feels that strongly about me, and I know they feel like I got off, and I know they feel like I should be punished, that they won't try to punish me. They do it with other people. Like you, I wouldn't have been around him. I wouldn't have been near him. I wouldn't trust him. Right, Jay. I hope that's not what it was. Because not only because, we don't want to say his cousin Ray, but if it was, that's going to piss Paige off. Because you just sat there in front of her and gave that long drawn out speech when you was getting your plea, and you said, I did the wrong things. I tried to help everybody. I tried to take everybody with me. I tried to have everybody around me. I'm too nice of a person. But this made me see. This opened my eyes. He gave that long animated speech where you could tell that man just couldn't even stop talking because he just wanted to go home. And if you are now allowing people back around you, not saying no, being too nice, not being aware of your surroundings, that man will make your life a living hell. And the fact that you wanted to get home to get to your kids, and what he have on the shelf, 40 years. You saw what she did to Moontoon, and Moontoon didn't have a choice but to lie. His plea deal had blatant lies in it with his initials to it, even though they had the emails to show that was not what was supposed to be in there. And so he had to sit on the stand and say what was in his plea deal, knowing that part of the stuff that was in his plea deal was a lie, and so did the DA. So if you don't think they will snatch you up on your son's senior night because they don't like what you said, 40 years will keep me in the house. When nobody see me, you have to come over my house. I'm not going nowhere. Not so long as there's an Instacart and I got money, I would be at somebody's house or somewhere with a water park and a roller coaster. Call it what you want. I can't. And I fancy myself an introvert, okay? In every way imaginable. The only thing that made me get a little bit more extroverted after already coming into my time, because my late teens and 20s I was outside, okay? So now I got to the point where I wanted to be inside until that pandemic hit, and then I wasn't allowed to go outside, and I want to go outside again. So I get it, not wanting to be locked up or locked away, but you can't go to those same, you can't be who you were. You can't be who you were. You can't keep around who wasn't around. And there's only a certain couple of people that probably is going to ever understand what you actually went through. And then to an extent, I don't even think Thug can relate to Shannon and Yak because he didn't go all the way through. Like, so get with somebody that you can. I just think you need to go sit back, be a daddy, make his music, enter into another creative space, find out what else he wants to do. But popping out, unless he's performing, he gonna have to take the Gucci Mane way. Gucci Mane and Keisha K.O. they ain't at nobody's club unless they paid. There are no events. And if he's performing, she's on the stage watching his back. It's, according to Thug, he had a ball in jail. He said that shit for a song. I don't care. Not after you had your attorney get up there and talk about how you living off of chips and your health is messed up. I don't think so. And ain't nobody gonna have fun being locked up nowhere. He got to let go. He's got to heal. He's got to talk to somebody. He's got to figure it out, because you can't keep playing with fire like this. You can't keep playing with fire like this. And I don't think it's fair to keep playing with fire, keep standing in an unhealed space, and then turn around and ask somebody to marry you and go down with it again. Like, that's not fair. That's not fair. That's not fair at all. All right, y'all. 10 a.m. Eastern Standard Time. Oh, that's 7 a.m. for me. I'll be getting the kids out. Okay. But 10 a.m. Eastern Standard Time, we will be up and at it for the sentencing of Judy Church. And I'm going to see if I can pull up some more information. He going to mess up the wedding because he going to have these people all around and all this bad noise on the internet. Just stay in the house. Just stay in the house. All right, y'all. Y'all be safe. I'll see y'all.